Good afternoon, everyone. Today I'm going to talk about Jack Smith's indictment against Donald Trump in Washington, D.C., that is, with respect to the January 6, 2021 riot, or insurrection, if you want to insist on calling it that. There's some legal developments going on which no one is picking up on, but which I believe point clearly to the fact that this prosecution is doomed. Now, the body is still a little bit warm, and there's no flies swarming around it, but it's walking dead. Let's go look at the indictment. Here it is. The indictment alleges 4 counts. Count 1 is conspiracy. Under this statute and the common law Pinkerton doctrine, you can be guilty of conspiracy even though you did not commit the underlying crime. For example, let's say you have a good friend who says, can you give me a ride down to the corner of First and Main? And you say, no problem, I'll give you a ride there. And he says, by the way, I'm going to rob the First National Bank. Okay, so you have a driver's license, your car is registered and insured. So giving him a ride in itself is not an illegal act. But because you know that he's going to commit a criminal act and giving him the ride is in furtherance of that criminal act, you're guilty of conspiracy. And you're guilty of the underlying crime as if you'd committed yourself. The only caveat on Section 371 is the maximum term of imprisonment is 5 years. Okay? Now let's go to the next one. Next count is 18 U.S.C. 1512K. Here it is. As you can see, this, it says here, whoever conspires to commit any offense under this section shall be subject to the same penalties as those prescribed for the offense, the commission of which was the object of the conspiracy. This tracks Section 371. The only reason why it's pulled into this indictment is it enables the penalty to be increased from 5 years for conspiracy to the underlying statute in this case, which is Section C2, which is 20 years. That's the only purpose it has. Now you see the big one here. 18 U.S.C. 1512 C2. Obstruction of an attempt to obstruct an official proceeding. Now this is the problematic section. And here, you can see this right here. So, see this is C1 and C2. They're only charging with C1 because C1 talks about destroying, mutilating, or concealing a document, etc. This section C was enacted in 2002 as part of the Corporate Accountability Act in reaction to some scandals, Enron, etc., where people destroyed documents while they knew that there was an investigation or other in a court proceeding going on. You notice that in C2, it also prohibits someone otherwise obstructs, influences, or impedes any official proceeding or attempts to do so. Now, there's 2 things I want to point out with this, 2 important points. The C2 is what we call a residual clause. That is, Section 1 outlines the offense, and 2 is, or otherwise does anything similar. In the last decade or so, the Supreme Court has made several rulings in the context of criminal law and so-called residual clauses. For example, there's a mandatory minimum sentence if you commit certain offenses and you are a career criminal. And these statutes basically says if you commit a crime of violence, blah, 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 or Section 2, otherwise any other crime of violence. Well, the Supreme Court has held that that residual clause is too vague in the criminal context of a career criminal, and so it's been struck down for most people. And in fact, the argument that has been made, and I think very cogently, is that this or otherwise obstructs in the residual clause is not independent on its own. In other words, it says, it basically stands for the preposition that if you do something similar to number one, but not exactly covered by that, well, you're included in a violation of the offense. That is problem number one. Problem number two is, what is an official proceeding? Now, there's no question that before the January 6th prosecutions, no one applied Section C to anything other than an investigative, prosecutorial, or judicial proceeding. It wasn't applied to any act outside the judicial branch. And this has been brought up in a case which has been appealed to the Supreme Court, actually under the certiorari rules, and the Supreme Court granted certiorari. And it involves a number of January 6 defendants who were charged under this very section C2. And their argument is, look, the residual clauses I mentioned, and also the fact that Congress was certifying the election, and that is not an official proceeding as ever understood under the statute. And they go into a lot of arguments about how you interpret statutes and all that. It's called Fischer versus United States, Fischer versus United States, granted certiorari, and they go on to point out what I said, that before January 6th, no court has ever applied this to other than a judicial or prosecutorial proceeding, like a grand jury. And also they point out that no circuit outside D.C. Circuit has interpreted it this way. D.C. Circuit's the only one. As a side note, there's another case. Let me look it up right here. Called the Brock case. This is related to it, not exactly the same, but related. This January 6th defendant called Brock, he was convicted of doing various things in the Capitol, and they also applied an enhancement to him because what he did affected the administration of justice. Now, an enhancement means that he was convicted of a crime, he's guilty, but they're adding more time to him because what he did affected the administration of justice. And he successfully argued, look, historically, administration of justice means the court. There's nothing about Congress certifying an election which has anything to do with the administration of justice. Now, Brock also made the same argument as the Fischer case because he was convicted under that statute, and the court says, well, sorry, we've already decided Fischer in favor of the government. We can't give you that, but we'll give you this on the enhancement, which there's over 100 January 6 defendants who have that same enhancement. So all things are topsy-turvy. But the district court and the circuit court in the District of Columbia have tried to walk this very fine line, saying we can't give them the enhancement, but we can convict them because we think Congress certifying the election is an official proceeding. Reading the court and what they've ruled on in the past with respect to the categorical approach, interpreting this residual clause, and also a similar case, the Yates case, leads me to believe that better than 80% chance this will be struck down, and even if Trump's convicted, he'll win an appeal. The Yates case is from a related statute enacted at the same time, where it's illegal to destroy a record when there's an official proceeding pending or contemplated. In Yates, this fisherman had caught some undersized fish, and the game warden saw him and said, "Stop, come back to the port." And allegedly, the fisherman threw the undersized fish overboard. And the government said, "You destroyed a record." And the Supreme Court says, "A fish is not a record." Okay, so Mr. Smith is pretty much dead on that. Okay, now for the final count, this is the weakest of all the counts, and that's why it's the last. It's conspiracy against rights. And this is basically intended to be, if you violate someone's civil rights, for example, George Floyd, then you're guilty of this also. The problem with charging on this is that the Supreme Court has not looked favorably upon the employment of this in other than strict civil rights cases. There's we call the Bridgegate case, that is where he was accused that certain people in Governor Chris Christie's office in New Jersey had closed the bridge in order to get some political points, and the Supreme Court threw it out. That count and all the other counts were thrown out. And I'd like to also point out that Mr. Smith does not have a good record with these political prosecutions. He did the first Menendez prosecution for bribery. He lost that at trial. He won again. It's the John Edwards campaign violation indictment where he used some money to pay his girlfriend, and that was overturned by the Supreme Court. And I think it's O'Donnell was the name of North Carolina. I think it's North Carolina congressman or elected official. He also went and also was overturned. So he has a history of overreaching. Well, that's my conclusion. Like I said, this proceeding, this case, indictment, it's the flies are going to be there soon. Okay, thanks. Hope you enjoyed this information today.